Well, good morning, all. This meeting is called to order. Mr. Troman, has anyone signed up for public comment?
Good morning, Commissioners. We have no registrants for public comment this morning.
Thank you very much. Good morning, Ms. Miller.
Good morning, sir.
How are we today?
Very well, thank you.
So we have a big agenda to tackle here.
Yes, sir.
All of your work. No cases to reconsider under agenda item 3.
That's correct. No cases.
All right. Well, then we'll move to agenda item 4 and consider tax liability cases. I think we have one tax case on docket 7 and one tax case on docket 8.
Yes, sir. That is correct. The case on docket 7 is TD-19-128-1119. Commissioner Demerson?
Agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
And the case on docket 8 is case number 19-059-0419. Commissioner Demerson?
Agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
Thank you.
Thank you. No fair housing cases on agenda item 5.
That's correct. No cases.
On agenda item 6, we have 2 wage claim cases pulled for additional discussion on docket 7, none on docket 8.
That's correct. The first case pulled on docket 7, case number 19-060-490-0. Commissioner Demerson?
I believe that we should hold a rehearing regarding the timeliness of the employer's appeal to the commission. Although the employer's testimony regarding non-receipt of the AT decision likely does not meet the standards of Commission Rule 815.032, the employer's attorney gave credible secondhand testimony that he did not receive a copy either. However, the attorney did not present firsthand testimony from the staff at his firm who routinely receive and process incoming mail. Since attorneys are bound by strict ethical standards, I believe that the attorney's testimony is sufficient to merit a rehearing for the purposes of allowing firsthand witnesses on the issue of non-receipt of the AT decision by the employer's attorney.
The employer's appeal should be dismissed as recommended. The decision was mailed to the employer's correct address of record, and the employer was unable to provide clear and consistent testimony to rebut the presumption of receipt. Likewise, the employer's attorney was unable to provide clear and consistent testimony to rebut the presumption of receipt at his address. Therefore, the employer's late appeal should be dismissed.
I concur with Commissioner Demerson.
Thank you. We will rehear this case. The second case is case number 20-052967-7. Commissioner Alvarez?
The decision is not supportable. The claimant has consistently provided and testified that he drove 18 loads for the employer at an agreed rate of $125 per load. The claimant earned $2,250. The claimant was not paid for the work he performed. The employer has not participated at any level of investigation and has provided no rebuttal to the claim. The claimant is entitled to $2,250 in total gross unpaid wages. Reverse, $2,250 wages owed.
The AT decision is supportable. Although the claimant's testimony was undisputed, the information that he offered lacked details as to the dates, times, and the specific duties he performed as a driver of the employer's truck. He submitted nothing in writing to support his verbal statements. Since the lack of evidence supports the AT's conclusion that the claimant offered insufficient evidence of the work performed, we should affirm the AT decision. The claimant is not entitled to wages from the named employer. In the alternative, I could support holding a rehearing for information regarding the fuel receipts allegedly bearing the claimant's signature. If necessary, the trucking company in possession of the fuel receipts allegedly signed by the claimant may be subpoenaed for the fuel receipts and any other documentation mentioned by the claimant that would be in the possession of that third party.
From the WCAT, wage claim dismissed, no wages owed.
Short form dissent?
Yes, sir, Commissioner Alvarez. And that was the last pulled case, a wage claim case rather, on docket 7. There are none pulled on docket 8. I did send you the wage claim short form dissent lists for both docket 7 and docket 8 a moment ago.
I'll move we accept staff recommendations on the remaining wage claim cases on docket 7 and docket 8.
I second the motion except for those cases on which I am dissenting, as reflected on the wage claim short form dissent list for docket 7 and docket 8.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for docket 7 and 8.
Motion passes with the exceptions noted. Move to agenda item 7, consideration of unemployment insurance cases on docket 7. Please proceed when you're ready.
Case number 2509981, Commissioner Alvarez.
The decision is not supportable. The claimant was the only party to appear and provide sworn testimony. The claimant denied he committed misconduct or that he had received warnings about his performance. Additionally, the employer has provided they were never satisfied with the claimant's performance as an executive chef in a 4 months he worked for the employer. As the employer has failed to provide sufficient evidence to establish misconduct and admitted they were never satisfied with the claimant's performance, the claimant should be qualified for benefits. Reverse the AT, no misconduct.
AT decision should be affirmed. The claimant failed to ensure that a customer order was placed on time, which resulted in the customer receiving an incomplete order. The evidence also shows that the claimant received prior warnings for various performance issues which were in his power to control. The claimant's denials are not credible because his testimony is inconsistent with his initial statements regarding prior warnings in his set schedule. Thus, the most credible evidence established that the claimant mismanaged his position of employment. To affirm the AT decision, misconduct.
Affirm the AT, misconduct.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2533157, Commissioner Dimerson.
The AT decision should be reversed. Regarding good cause, the employer, a school district, was closed due to the pandemic and the AT decision was mail. The COVID-19 pandemic disrupted the employer's operations and access to mail in district facilities. Staff had only limited access to the facility for a few hours once a week to check their mail. Thus, significant circumstances beyond the employer's control contributed to the delayed receipt of the hearing notice. Under these facts, the employer had established good cause for its non-appearance and the case should be resubmitted for merits testimony. However, even if my fellow commissioners do not agree that the employer established good cause, we should reverse on the reimbursement issue. The available evidence shows that the claimant, when continuing work was available. There's no evidence that the claimant had good cause to quit. Accordingly, we should reverse the AT decision. The employer had good cause for its non-appearance, resubmit for merits testimony, or in the alternative, modify the AT decision. The employer did not have good cause for its non-appearance, reimbursing employer not billed.
The AT decision should be affirmed. The employer did not establish good cause for their non-appearance at the AT1 hearing because nobody was checking their mail and therefore did not deliver the notice of telephone hearing to the person who was supposed to participate in the hearing. On the separation, there is no facts on the record that show that the claimant was separated under disqualifying circumstances. Affirm the AT2. Employer did not establish good cause for their non-appearance at AT1. Bill the reimbursing employer.
Modify the AT. Employer did not establish good cause for AT1. Reimbursing employer not billed.
Commissioner Alvarez, do you have a dissent?
Yes, short form dissent. Sorry.
Thank you, sir.
Case number 2615852, Commissioner Alvarez.
The decision should be reversed. No voluntary leaving, MVI, and no overpayment. The claimant was pregnant and smells in the workplace aggravated her morning sickness. The employer tried to accommodate the claimant by moving her to a new department, but she continued to get sick at work. Therefore, the claimant was forced to quit due to her medical issue. After her separation, the claimant sought medical care and was given medication and work restrictions. The employer did not dispute the claimant's version of events or that her separation was caused by her medical issue. Therefore, the claimant should be qualified for benefits. Reverse the AT, no voluntary leaving, MVI, and no overpayment.
The AT decision should be affirmed. The claimant quit without the advice of her doctor and without requesting further accommodation or leave of absence from the employer. As the claimant has provided insufficient medical documentation to establish a resignation for medical reasons, she should be deemed kept without work-connected good cause. We should affirm the AT decision, voluntary leaving, overpayment of $859.
Reverse the AT, no voluntary leaving under section 207.045G1, no overpayment.
Short form.
Yes, sir, Commissioner Demerson. And Commissioner Alvarez, the chairman's vote agrees with yours, but it's under a different rationale.
Ms. Miller, I will agree with the chairman's vote.
Thank you.
And Sherry, let me add to my short form, if I may, to send a memo to UIO and CS to investigate the claimant's ability and availability for full-time work.
Yes, sir. We'll send a memo to UIO and CS.
Thank you.
Case number 2617052, Commissioner Alvarez.
The motion for rehearing should be granted. The claimant stated his appeal to the commission was late because he was unable to get into contact with the agency despite numerous calls. When he did receive a call back after the deadline, he was informed he could still file an appeal. The claimant has never had a hearing to address the timeliness of his appeal. As the claimant was unable to receive assistance with the decision due to high call volume and has not been provided the opportunity to testify regarding the timeliness of his appeal, the motion for rehearing should be granted and timeliness testimony taken. Grant the motion for rehearing.
The claimant's MR should be denied. To the extent that the claimant has provided new evidence about his late appeal to the commission, he gave no compelling reason as to why this evidence was not offered earlier. Further, the information provided will not change the outcome of this case. The claimant maintains that he knew about the AT decision, understood the deadline, but delayed appealing because he wanted to speak to a UI representative. The appeal instructions were clear in the decision he received, and he was not misled by an agency representative. Given these facts, the claimant has not shown that he has met the 3 requirements for a successful MR. As such, we should deny the claimant's motion for rehearing.
Deny the motion for rehearing.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2627381, Commissioner Alvarez.
This case should be reheard. It took the majority of the hearing to obtain a translator for the claimant. Even after the translator was obtained, the claimant continued to have issues understanding what was going on and notably confused. Due to these issues, we should rehear the case to ensure the claimant has adequate access to a translator.
AT decision should be affirmed. The claimant's resignation letter in evidence states that she quit because the job did not fit her personality. The alternative, the claimant quit in anticipation of discharge. Neither of these reasons constitute good work-connected cause for quitting. As such, we should affirm the AT decision, voluntary leaving, no chargeback.
Rehear.
We will rehear this case.
Case number 2631282, Commissioner Alvarez.
The decision should be modified. The claimant was separated from employment when he had to quarantine because a household member tested positive for COVID-19. The claimant notified his account manager that he was required to quarantine. The claimant's separation due to a required quarantine was not disqualifying. Modify the AT, no voluntary leaving, no chargeback, disaster.
The appeal tribunal decision should be affirmed. The claimant quit his job for personal reasons. Additionally, the claimant appears to have intimated that problems with his vehicle also contributed to his not being able to return to work. As such, the claimant resigned without work-connected good cause. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback, memo to UIO and CS to investigate eligibility for PUA.
Short form dissent.
Yes, sir, Commissioner Alvarez. And Mr. Chairman, we will send a memo.
Thank you.
Case number 2632328, Commissioner Alvarez.
The decision should be reversed. The claimant stopped working and was separated from her client when her client went into the hospital. The claimant informed the employer of the hospitalization and was not offered any additional work. The claimant remained in contact with the employer and notified them when the client went into hospice care. The claimant asked the employer for additional work and was again not given any work at the time. The claimant was not offered more work until she had been without work or earnings for 6 weeks and had already filed for benefits. As the claimant was without work or earnings through no fault of her own, the claimant should be qualified for benefits. Reverse the AT, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. According to the commission president, in the home health care referral industry, the working relationship continues until one party clearly notifies the other that the relationship is ended. In this case, the claimant initiated the job separation by filing her initial claim after notifying her supervisor that her client had been hospitalized. According to the claimant's fact-finding statements, which were taken closer to the time of separation, it appears that the claimant left the job due to her family and COVID concerns, which are personal reasons. The claimant's quitting was therefore without work-connected good cause. Accordingly, we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2642017, Commissioner Dimerson.
The commission should grant a rehearing in this case. The claimant was discharged after a customer overheard her on a personal call using profanity. The employer maintains that it submitted a recording of this event, but the hearing officer could not find it, nor does it appear that TWC has received such evidence. Since the employer stated that it had sent a recording of the final incident to the commission, but could not be located, we should conduct a rehearing to allow the employer to resubmit its audio recording of the final incident.
The AT decision should be affirmed. The claimant was accused of using profanity towards a customer. The claimant has consistently denied the allegations, and the employer has failed to provide firsthand testimony or direct evidence of the alleged incident. The employer has failed to meet its burden to establish misconduct by the claimant. A rehearing is not in order in this case. While the employer representative indicated at the AT hearing that they had provided a recording of the incident, such evidence was not found in commission records. The employer again has not submitted the alleged recordings with its appeal to the commission or even referenced the recording in the appeal. A rehearing is therefore not warranted based on these circumstances. Affirm the AT, no misconduct, chargeback.
Rehear.
We will rehear the case.
Case number 2642933, Commissioner Alvarez.
The decision should be reversed. When the employer's store reopened following the lockdown, the employer failed to provide masks or face shields. The employer deliberately scheduled less employees in what it called a safety measure, while increasing the workload with increased sanitation tasks for a few employees who were working. The claimant was working substantially more hours. The claimant, who is in high-risk group for COVID, was not even allowed to ask customers to wear masks. The unsafe work environment provided the claimant good cause for quitting. Reverse AT, no voluntary leaving.
The appeal tribunal decision should be affirmed. The claimant quit her job due to fear of COVID-19. However, both parties agreed that the employer implemented safety protocols at the workplace. In addition, the claimant was willing to assist in any way necessary in case the transition process, presumably resulting from the need to replace the claimant, lasted longer. This establishes that working conditions were not intolerable. As such, the claimant's resignation, while work was still available, was without work-connected good cause. We should therefore affirm the AT decision, voluntary leaving.
Affirm the AT, voluntary leaving.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2643159, Commissioner Alvarez.
The decision should be reversed. The employer testified that the claimant the claimant failed several audits, but never provided any factual basis to support the allegations that she was making errors in her coding. The claimant testified that she had over a decade of experience in coding and never had an issue until the employer hired a new auditor who did things differently. The evidence fails to establish misconduct. Reverse the 18, no misconduct, bill reimbursing employer.
The appeal tribunal decision should be affirmed. The claimant was discharged for poor job performance. The claimant had been issued warning, notifying her that termination could result if she did not improve. Nevertheless, she did not improve sufficiently, and her failure to do so was the equivalent of work-connected misconduct. We should therefore affirm the AT decision, misconduct, reimbursing for and not billed.
Affirm the AT, misconduct, reimbursing employer, not bill.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2644870, Commissioner Alvarez.
The decision is not supportable. The claimant is 71 years old and has underlying health conditions. At the start of the pandemic, the claimant was sent home where she was able to perform 100% of her job duties remotely. After 4 months, the employer instructed the claimant to return to the office or be subject to forced resignation. Additionally, the employer wanted the claimant to rotate onto the front desk, a duty she had not performed in 3 years and in which would put her into contact with the general public. The claimant had been instructed by the doctor that she would work from home. The claimant attempted to work out alternatives with the employer and followed all instructions for accommodations. When all alternatives and accommodations were denied and the claimant was still instructed to work in the office against her doctor's instructions, the claimant resigned. Since the claimant's resignation was due to her age, underlying health conditions, and her increased risk to the pandemic, she should be qualified for benefits. Reverse AT, no voluntary leaving, disaster, bill employer.
The appeal tribunal decision should be affirmed. The claimant quit her job due to concerns about COVID-19. The claimant contends she has medical documentation from her doctor. However, no such documentation appears in the record. While the claimant states that the letter from her doctor advised her that it was best for her to work from home, the claimant never stated that her doctor advised her to quit her job. As such, the claimant's resignation was without work-connected good cause. We should therefore affirm the AT decision, voluntary leaving, reimbursing employer, not billed.
Affirm the AT, voluntary leaving, reimbursing employer, not billed.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2659615, Commissioner Alvarez.
The decision should be modified. The claimant quit to care for his wife after she was released from the hospital with a preliminary diagnosis of liver and colon cancer. The claimant was not questioned by the AT about whether his wife's illness was believed to be terminal, but liver cancer has a high mortality rate. The claimant quit to care for his terminally ill spouse. Modify the AT, no voluntary leaving, no chargeback, terminally ill spouse.
We should affirm the appeal tribunal decision. There is no doubt that the claimant quit his job for a very compelling personal reason. However, his reason for quitting is not work-related and does not meet any of the statutory exceptions to disqualification. We should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no charge.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2693142, Commissioner Alvarez.
The decision should be reversed. The claimant was taken off work indefinitely to stabilize her epilepsy. The claimant provided medical documentation in March regarding her medical condition and need for leave. The claimant maintained contact with her employer. The claimant testified that the third-party administrator claimed not to have received medical documentation, but the employer's response to the commission never alleged that the claimant failed to produce medical documentation. The third-party administrator did not appear to offer evidence to that effect. The claimant stopped working due to a medical condition. Reverse AT, no voluntary leaving, MVI, void chargeback.
We should affirm the appeal tribunal decision. The claimant admitted that her supervisor had instructed her to call in every day until her medical paperwork was submitted. Despite this instruction, the claimant did not report to the employer for several days, even though she knew that the paperwork had not been completed. By failing to call the employer as instructed and being absent without notice for several days, the claimant mismanaged her position of employment. We should affirm the AT decision, misconduct, void chargeback.
Affirm the AT, misconduct, void chargeback.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2700364, Commissioner Dimerson.
We should modify the appeal tribunal decision. First, I agree that the claimant filed a timely appeal. As to the job separation, since the claimant's hours were reduced by the employer is the party who initiated the job separation. Thus, this case should be decided under section 207.044 of the Act. Furthermore, because the drastic reduction in the employer's business was caused by COVID-19 natural disaster, the claimant should be qualified for benefits and the employer's account should be protected from charge. Should not penalize the employer for trying to keep its employees working some hours rather than resorting to a complete furlough. Accordingly, we should modify the AT decision, timely claimant appeal, no misconduct, no chargeback, separation caused by the disaster.
Ms. Miller, I would agree with Commissioner Demerson.
Concur.
Thank you. We have a unanimous decision.
Case number 2701448, Commissioner Dimerson.
We should grant a rehearing in this case. First, although it appears to have been sent via fax, the employer's appeal bears no sent or received dates. Furthermore, if sent via regular mail, our records contain no copy of the envelope in which the appeal would have been received. Thus, our records appear incomplete. In its appeal to the commission, which was submitted online, the employer states that it submitted the appeal in question prior to the deadline and that the employer has documentary proof of the timely filing. We should note that our time online appeals method does not allow for the inclusion of separate documents with an appeal. Due to the irregularities of the appeal in our records, and considering the employer's assertion that it has tangible proof of a timely appeal, we should rehear this case and allow the employer an opportunity to provide this evidence.
The decision should be affirmed. The employer received the determination prior to the appeal deadline. However, the employer filed a late appeal because they laid off many people. As this does not fit a timeliness exception, the employer's appeal was properly dismissed as late. Affirm the AT late employer appeal, bill reimbursing employer.
Rehear.
We will rehear the case.
Case number 2702673, Commissioner Alvarez.
The decision should be reversed. The claimant did not quit. The COO, who provided testimony on the employer's behalf, refused to characterize the job separation as a resignation. After initially telling the commission in statements and in testimony that the claimant said, "Start replacing me," the COO eventually admitted in testimony that the claimant never said that and merely expressed frustrations with the working conditions. The claimant never stated that he was quitting, and expressing frustration with the working conditions is not misconduct. Reverse AT, no misconduct, chargeback.
We should modify the appeal tribunal decision. When presented with two very different versions of events, the appeal tribunal gave credence to the employer. There is no reason to disturb the AT's finding on this issue. The claimant communicated to the employer that he was dissatisfied with his job and asked the employer to start looking for the claimant's replacement. This gave the employer the reasonable impression that the claimant was quitting. The claimant may have later regretted his decision, but the employer had already acted in reliance of the claimant's statements during multiple conversations between the parties. Because the employer presented credible and persuasive evidence that the claimant initiated the job separation and the claimant did not establish that his working conditions were intolerable, we should modify the AT's decision, voluntary leaving, no chargeback, add adequate employer response ruling.
Reverse the AT, no misconduct, chargeback.
Short form.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2710200, Commissioner Alvarez.
The decision is not supportable. The determination was sent electronically to the claimant during the period in which the agency was experiencing issues with the online system. The claimant has testified that she was unable to contact a representative due to the high call volume and submitted earlier appeals without receiving a confirmation. Since the claimant was experiencing problems with the system, unable to contact a representative, and submitted earlier appeals, her appeal should be deemed timely and resubmitted. Reverse AT, deemed timely and resubmit.
We should affirm the appeal tribunal decision. The claimant failed to open the determinations until after the appeal deadline had passed. This was also outside the window of time that TWC experienced technical difficulties. The claimant cites confusion as the reason for not filing a timely appeal. There's no good cause exception to the timeliness rules, and the claimant does not meet any of the recognized exceptions to timeliness. Her appeal is late. Since we do not have jurisdiction to consider the underlying merits, we should affirm the AT decision. Untimely claimant appeal, severance disqualification, March 15th, 2020 through April 4th, 2020, overpayment of $1,042.
Reverse the AT, timely claimant appeal, resubmit.
We will resubmit the case.
Case number 2715258, Commissioner Alvarez.
The decision is not supportable. At the time the pandemic began, the claimant had several events scheduled where she would speak and sell her book. When the pandemic began, the claimant still had books in stock. The events were canceled due to the pandemic, and the claimant could not work while there were restrictions on holding large gatherings. The claimant is eligible for pandemic unemployment benefits. Reverse AT, claimant eligible for pandemic unemployment assistance. Memo to request backdating the claim to 3/8/20.
The AT decision is not supportable. The claimant offered sufficient credible testimony regarding her last work for her grandson during biweekly housekeeping. The evidence indicates that the claimant had to stop the house cleaning work due to concerns about the pandemic. Under these circumstances, the claimant should be able to maintain a claim for pandemic unemployment assistance benefits. It is also possible that the claim could be backdated to an earlier point in 2020, but the UI division will need to investigate that issue. Accordingly, we should reverse the AT decision. The claimant filed a valid PUA claim, sent a memo to UIO and CS regarding backdating the claim to March 2020.
Ms. Miller, are those votes sufficiently the same?
Well, both parties have voted to reverse. Both the commissioners have reversed in the claimant's favor. The only difference between them is the date that they're requesting the claim to be backdated to. Commissioner Demerson didn't specify which day in March.
I concur with Commissioner Demerson.
Thank you. We will send the memo to UIO and CS to investigate whether the claim should be backdated to March 2020.
Okay.
Commissioner Alvarez, did you have any comments since
No.
this is exactly what you voted?
Ms. Miller, I'm fine with the consensus of the two commissioners.
Thank you, sir.
Case number 2721799, Commissioner Demerson.
I'm going to just recuse myself from voting on this case. This particular case.
Okay. The AT decision is not supportable. The claimant was a substitute teacher. She was held ineligible during the summer break between school terms because she was held to have reasonable assurance of continued work at the beginning of the fall school term. The claimant was not able to return to work at the beginning of the fall term because the vast majority of the students in her school district are attending school remotely, and there are therefore no substitute teacher jobs available. The employer's reasonable assurance letter specifically provides that it does not guarantee reasonable assurance to substitute teachers in the event of a natural disaster. Since it turned out that the claimant did not have reasonable assurance of continued work at the beginning of the new school term, the ineligibility should be reversed. Reverse the AT, reasonable assurance eligible, no overpayment. I would also agree to a rehear to have information as to the availability of a substitute teacher jobs in the new school term placed on record.
I'd agree to that rehearing.
We'll rehear the case. And that was the last pulled UI case on docket 7. Earlier in the meeting, I did forward you the UI short form dissent list for docket 7.
I'll move we accept staff recommendations on the remaining UI cases on docket 7.
Chairman, I second the motion except for those cases in which I am dissenting as reflected on the UI short form dissent list for docket 7.
Concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 7.
All right, the motion passes with the exceptions noted.
Continuing to docket 8, sir.
Right,
Case number 2584806, Commissioner Alvarez.
The decision is not supportable. Commission records reflect that the determination was sent to her electronically instead of by U.S. Postal Service. Staff have confirmed that it would have been impossible for the claimant to view correspondence because she signed up for a second UBS account, which prevented her Social Security number from being associated with the account. Because the Texas Workforce Commission failed to properly mail the determination, the claimant's appeal should be deemed timely and resubmit.
The AT decision should be affirmed. Commission records indicate that the claimant signed up for electronic correspondence. She did not change her election when she filed this claim. It was the claimant's responsibility to keep her contact information current and to continue checking her electronic correspondence. The determination was properly sent to the claimant via her chosen delivery method, but she did not open the determination or file her appeal until months later. Thus, the claimant's appeal is late and we do not have jurisdiction to consider the underlying merits. Accordingly, we should affirm the AT decision, untimely claimant appeal, voluntary leaving, no chargeback.
from the AT, untimely claimant appeal, voluntary leaving, no chargeback.
Long form dissent.
Yes, sir. I have your long form dissent.
Case number 2587435, Commissioner Dimerson.
The AT decision should be modified. I do not dispute that the claimant quit due to her pregnancy, which constitutes a qualifying separation due to medical reasons. However, I disagree with the AT's conclusion that the claimant's pregnancy provided her with good work-connected cause to quit. The claimant quit for personal reasons, and the MVI provision of the Act operate as an exception to disqualification. It does not state that a claimant who quits for medical reason has good cause to resign. As such, the claimant should continue to be qualified for benefits, but the employer should not be billed because the claimant ultimately quit for personal reasons. In addition, based on the evidence regarding the claimant's bed rest and the birth of her child, a memo should be sent to UIA and OS to investigate the claimant's availability and ability to work. As such, we should modify the AT decision, no voluntary leaving, reimbursing employer not billed, MVI, and send a memo to UIA and OS to investigate the claimant's availability and ability to work.
The decision should be affirmed. Both parties agree that the claimant stopped working in March of 2020 because she was on approved unpaid FMLA leave due to her pregnancy. Because the claimant was not working or earning wages, she was considered unemployed for the purpose of unemployment benefits. Because the claimant stopped working for medical reasons, the job separation was non-disqualifying. Affirm the AT, valid claim, no voluntary leaving, bill reimbursing employer.
Affirm the AT, no voluntary leaving, bill reimbursing employer, memo to UIO and CS to investigate claimant's ability to work, availability due to childcare, and whether there are possible unreported earnings.
Short form.
Yes, sir, Commissioner Dimerson, I have your short form dissent. And Mr. Chairman, I have a memo on availability for childcare and possible unreported earnings.
Correct.
Case number 2604262, Commissioner Alvarez.
The AT decision is not supportable. The employer has alleged that the claimant was discharged as a result of an altercation with a coworker in which the claimant injured the coworker. The employer has presented only hearsay evidence of its allegations, and the claimant has consistently denied wrongdoing. The employer has failed to meet its burden of establishing the claimant's misconduct by the preponderance of the evidence. Reverse the AT, no misconduct, bill reimbursing employer.
The AT decision should be affirmed. The claimant admitted to behaving inappropriately in front of the patient and other employees. The claimant outburst at work violated the employer's standards of conduct, and the claimant should have known that such unprofessional behavior in front of a patient could lead to discharge. Therefore, affirm the AT decision, misconduct, reimbursement or not billed.
Affirm the AT, misconduct, reimbursing employer not billed.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2609267, Commissioner Alvarez.
The decision should be reversed. While the claimant was 7 months pregnant, a coworker pushed her at work. The claimant responded by making an excited utterance, which is understandable under the circumstances. As the claimant was physically assaulted at work and her reaction was understandable, her actions do not rise to the level of misconduct. Reverse AAT, no misconduct, chargeback, sever validity of claim.
The AT decision should be modified to sever the validity of claim issue. As to the job separation, the claimant's testimony is self-disqualifying because she admitted to cursing at another employee in front of customers. The claimant knew that her actions violated company policy. Neither the claimant's pregnancy nor her co-workers' actions excuse the claimant's use of such profane language in the workplace. It was not necessary for the claimant to curse, and her actions constituted work-connected misconduct. We should modify the AT decision, misconduct, no chargeback, sever the validity of claim issue.
Modify the AT, misconduct, no chargeback, sever validity of claim.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2612694, Commissioner Alvarez.
The decision should be modified. No voluntary leaving, no chargeback. The claimant's wife has a rare form of cancer that the Social Security Administration classified as a compassionate care disease. This is another way of saying that she is terminally ill. As the claimant quit to care for his terminally ill spouse, he should be qualified for benefits and the employer's account protected from charge. Modify the AT, no voluntary leaving, no chargeback under section 207.046A3. In the alternative, we could also rehear the case for additional documentation as the claimant was not previously asked to provide documentation.
I'll also agree to rehear this case, develop the record on whether the claimant could qualify under the terminally ill spouse provision of the Act.
Modify the AT, no voluntary leaving under section 207.046A3, no chargeback.
Ms. Miller, I would agree to the no volunteering leaving, no chargeback terminally ill spouse. Mr.
Yep.
Chairman.
Yes, sir. There is a majority vote that the claimant is qualified based on terminally ill spouse. Commissioner Demerson, do you have any dissent?
Yep, I want a short form dissent and send a memo to UIA and OS to investigate the claimant's availability for full-time work.
Yes, sir. We'll send that memo.
Thank you.
Case number 2617208, Commissioner Dimerson.
The AT decision should be reversed. The claimant exceeded 60 hours of missed work, which was a violation of the employer's attendance policy, of which the claimant was aware. On the final incident date, the claimant took a half day off from work without prior approval from management, despite receiving a final warning for attendance. The evidence also shows that the claimant had a habitual attendance problem and that he failed to take adequate steps to protect his job. The claimant mismanaged his position of employment, and we should reverse the AT decision. Misconduct, chargeback, adequate employer response. In the alternative, the commissioners should grant a rehearing in this case to obtain corroborating medical documentation from the claimant and to develop the record on when the appointment concluded.
The decision should be affirmed. The claimant had requested and had been granted half a day off to take his wife to an oncology appointment. The claimant realized that the appointment was going to take longer than expected and sent his supervisor a text that he would be out for the entire day. Consistent with the precedent cited by the AT, the employer was on notice that the claimant was attending to personal matters, which might delay him longer than expected. Therefore, his absence from work was not misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent?
Yes, sir, Commissioner Alvarez. I have that dissent.
Case number 2628549, Commissioner Alvarez.
The AT decision should be reversed. The claimant left the job due to concerns with COVID-19. The claimant's wife has a medical condition that makes her vulnerable to severe illness from COVID-19. The claimant was in fear for his wife since employees were not social distancing or otherwise taking precautions. The employer's representative admitted in testimony that the employer did not have any COVID-19 protocols in place. The claimant therefore had good cause connected with the work to resign from the job in light of the risk of COVID-19 posed to him and his wife. Reverse the AT, no voluntary leaving.
I agree that the claimant should be qualified due to the disaster. However, a memo should be sent to UIA and OS to investigate the claimant's availability for full-time work. We should reverse the AT decision, no voluntary leaving, disaster, a memo on availability.
I concur with Commissioner Demerson.
Thank you. There is a unanimous vote that the claimant shall receive benefits or will be qualified for benefits. Disaster impacted claim. Commissioner Demerson will also send the memo that you requested.
Thank you.
Case number 2628578, Commissioner Dimerson.
The appeal tribunal decision should be modified. First, since the employer was not in the claimant's base period, the chargeback ruling should be voided. As to the job separation, the case should be analyzed under section 207.045 of the Act. The claimant was arrested and per his fact-finding statements, had to serve jail for 14 days. The employer stated in its initial response that the claimant went to jail and never showed up for work. Accordingly, since the claimant could not manage his personal life in a way that would allow him to show up for scheduled work, he effectively quit his job for the personal reasons of needing to serve jail time, which is a reason that is not without good cause connected with the work. We should therefore modify the AT decision, voluntary leaving, void chargeback.
The decision should be reversed. The claimant's girlfriend provided notice of his absence to the employer because he was unable to do so. The supervisor told the claimant that he still had a job. When the claimant was able to return to work, the employer had closed due to COVID. The claimant's absence was permission of his supervisor was not misconduct. With permission of his supervisor was not misconduct. Modify the AT, no misconduct, void chargeback.
Affirm the AT, misconduct, void chargeback.
Short form dissent.
Okay, thank you. I will mark your short form dissent, Commissioner Alvarez. We don't have a majority vote on the section of law yet. The majority vote is to disqualify the claimant. Commissioner Demerson, you pulled this case.
Yeah, I'm fine with misconduct, as the chairman mentioned.
Thank you very much.
Thank you.
Case number 2631787, Commissioner Alvarez.
The AT decision is not supportable. The claimant provided credible firsthand testimony that she missed one day of work due to personal illness and thereafter went to the workplace 3 days to see if any assignments were available. The claimant was not scheduled for additional work, nor was she offered further work. The preponderance of the evidence establishes that the claimant was laid off due to the lack of work and did not quit the job. Reverse the AT, no misconduct, no overpayment.
The AT decision should be affirmed. The AT was in the best position to determine the credibility of the parties, and as such, the employer's evidence should hold more weight since it was more consistent than the claimant's statements. The evidence established that the claimant was a no-call, no-show for several days, and she failed to clarify her job status with the employer. Thus, the claimant should be disqualified whether this case is viewed as a resignation or as a discharge, since the claimant failed to take adequate steps to protect her job. Accordingly, we should affirm the AT decision, voluntary leaving, overpayment of $490.
Reverse the AT, no misconduct, no overpayment.
A short form.
Yes, sir, Commissioner Demerson.
Case number 2636092, Commissioner Alvarez.
The AT decision is not supportable. The claimant worked for the employer on call as needed. While she originally worked 5 days per week, the employer had reduced the available assignment to once a week. The claimant was involuntarily separated at the end of her last assignment since she worked as needed. She therefore was involuntarily separated for non-disqualifying reasons. Reverse the AT, no misconduct. In the alternative, even if it's determined that the claimant quit the job, she had good cause connected with the work to quit, since the employer had reduced the available work to 1/5 of what had previously been offered. Reverse the AT, no voluntary leaving.
I agree that the claimant separation was a disaster. Accordingly, we should reverse the AT decision, no voluntary leaving, separation due to disaster.
Reverse the 18, no voluntary leaving, disaster.
Thank you. We have a unanimous decision.
Case number 2646753, Commissioner Alvarez.
The AT decision should be reversed. The claimant took a temporary furlough from the employer because of his concerns about COVID-19. The employer was not enforcing safety precautions such as face mask or social distancing. Also, the available bathrooms had no soap, and the workers exposed to other infected workers was not required to quarantine. Since the claimant has family members who live with him and are at risk of severe illness from COVID-19, he chose to temporarily stop working. The claimant had good cause connected with the work to resign in light of the vulnerability of his family members and the employer's failure to maintain a safe workplace. Reverse the AT, no voluntary leaving, no overpayment.
I agree that the claimant should be qualified due to the disaster. We should reverse the AT decision, no voluntary leaving, separation due to disaster, no overpayment.
I concur with Commissioner Demerson.
Thank you. We have a unanimous decision.
Case number 2648661, Commissioner Alvarez.
The decision should be modified. No voluntary leaving, no chargeback. The claimant exhausted his FMLA leave while taking care of his wife, who was severely ill. The employer advised the claimant to take a leave of absence when his FMLA leave was exhausted, and the claimant filled out the necessary paperwork. The claimant filed for unemployment benefits while on leave because he was not working or receiving pay. Additionally, the employer's policy prohibiting the claimant from filing for benefits is not enforceable. The claimant's separation was urgent, necessary, and compelling. He should be qualified for benefits under Section 207.046 and the employer's account protected from charge. Modify the AT, no voluntary leaving, no chargeback under Section 207.046.
The AT decision should be affirmed. The claimant quit when he took an indefinite leave of absence for personal reasons. Unfortunately, none of the exceptions to disqualification apply to the current facts of the case. The job separation cannot be deemed urgent, compelling, and necessary since the reason for resignation was not related to the work. I also cannot agree to qualify the claimant under Section 207.046A3 since the record is insufficient to establish that the claimant's spouse is terminally ill and that no reasonable alternative care was available. Thus, the claimant quit without work-connected good cause, and we should affirm the AT decision, voluntary leaving, no chargeback. However, I would agree to rehear this case to develop the record on whether the claimant could qualify under the terminally ill spouse provision of the Act.
On the AT, voluntary leaving, no chargeback.
Okay, one moment, please. All right, majority vote is to affirm the AT, no voluntary leaving and chargeback. Commissioner Alvarez, do you have a dissent?
Yes, short form dissent.
Yes, sir, thank you.
Yeah, and I think I have voluntary leaving.
VLXX, voluntary leaving.
Correct.
Yes, sir, that's the majority vote.
Okay, thank you.
Case number 2652154, Commissioner Alvarez.
The decision should be modified. The claimant was forced to miss work when the pandemic disrupted his child care by closing schools. This was outside of the claimant's control. He should be qualified for benefits. Further, as the separation was caused by the pandemic, the employer's account should be protected from charge. Modify the AT, no voluntary leaving, no chargeback, separation caused by disaster.
The AT decision should be affirmed. The claimant quit due to a lack of childcare, which is a personal reason. Unfortunately, none of the exceptions to disqualification apply to the facts of this case. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Ms. Miller, short form dissent and memo to PUA, claim backdated to the time of the claimant's initial separation.
Have your short form dissent, and we will send that memo.
Case number 265-6870, Commissioner Alvarez.
The decision should be reversed. The claimant informed the employer that her manager was sexually harassing her. The manager was fired, but on other grounds, and the claimant was prohibited from discussing the issue. Co-workers began to harass the claimant because they blamed her for the manager's discharge. The co-workers' hostility included throwing clean linen on the floor, which caused the claimant to have to rewash the linen. The claimant complained to her supervisor and to the director of nurses, but no assistance was provided, and the situation did not improve. Therefore, the claimant had good cause to quit. Reverse the AT, no voluntary leaving, chargeback.
The AT decision should be affirmed. The employer credibly testified that she addressed the claimant's initial concerns and took corrective action. The claimant agrees that the corrective action was taken, thereby resolving her complaint. However, the claimant did not communicate her true concerns to the owner prior to resigning. Since the claimant quit before giving the employer a reasonable opportunity to address her new grievances, she quit with work-connected good cause. We should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 265-8119, Commissioner Dimerson.
The commission should grant a rehearing in this case. Both parties agreed that the claimant was supposed to call a particular entity in order for the claimant to secure the permission he needed in order to his tower. While the claimant contends that he cleared everything with that entity before leaving his tower, the employer, in its appeal to the commission, states that they have an audio recording of that entity telling the claimant that the tower was not operational. Since this evidence is critical in making a thorough evaluation of the credibility of the parties, we should hear the case for the employer's audio recording.
The AT decision should be affirmed. The claimant left work when his work site was operational and after he had received permission from the employer's network operations to leave. After he left, another issue, a different site, arose, and the claimant returned to address it. The claimant acted in accordance with the employer's policies and was therefore discharged for reasons other than misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Rehear.
We will rehear the case.
Case number 265-9495, Commissioner Alvarez.
The AT decision should be modified. The claimant has very high blood pressure and was advised by his doctor to find a less stressful job. In accordance with his doctor's recommendation, the claimant resigned from his employment of over 10 years with the employer. The claimant was separated due to a medically verified illness and should not be disqualified. Modify the AT, no voluntary leaving, no chargeback due to MVI.
The appeal tribunal decision should be affirmed. The claimant quit his job due to medical reasons. However, the claimant did not provide any medical documentation to the employer. As noted in the precedent case cited by the AT, when a claimant leaves his last work due to alleged medical reasons but produces no medical verification to his employer, it is supportable to find that the claimant left his work voluntarily and without good cause connected with the work. Accordingly, we should affirm the AT decision, voluntary leaving, no chargeback.
Modify the AT, no voluntary leaving, no chargeback, MVI.
And I wouldn't agree with that.
I'm sorry, Commissioner Dimerson, did you say you do agree?
Yes, I'm fine with it. I agree with that.
Thank you. We have a unanimous decision.
Case number 2681261, Commissioner Dimerson.
The AT decision should be reversed. The home health care precedent applies to this case. Therefore, the employment relationship continued until one party notified the other that the relationship had ended, even if there was a passage of time between assignments. In this case, the claimant's last assignment ended after she continued to call in absent to work, and the client requested the claimant be removed from the assignment. Thereafter, the employer offered the claimant several assignments, none of which the claimant accepted. The employer's policy required the claimant to respond to offers of work, and her job description states that failure to respond to an offer constitutes a rejection of that offer. Thus, despite there being several days between the new offers of work, the employment relationship in this case continued until the claimant stopped responding to the employer's offers of work. As there's no evidence that the claimant had good cause to reject further work, she quit without work-connected good cause, and we should reverse the AT decision. Voluntary leaving, no chargeback, adequate employer response.
The decision should be affirmed. The claimant was absent from her last assignment with notice. The employer did not consider this to be misconduct and was willing to place the claimant on a new assignment, but was unable to do so because no assignment was available. The claimant was separated from employment when she went over a week without an assignment. Affirm the AT, no misconduct, chargeback.
Affirm the 18, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Thank you.
Case number 2687902, Commissioner Dimerson.
This case should be remanded back to the AT because there were several problems with the AT hearing and procedure. It's unclear whether the AT properly developed the record. Specifically, the hearing officer questioned the employer about an unrelated wage verification notice instead of the chargeback liability decision connected to this claim. As a result, the employer's testimony on the timeliness issue is unclear and unreliable. We should cure these issues and properly develop the record on timeliness before rendering a decision in this case. Accordingly, this case should be remanded back to the AT for the reasons so stated.
The decision should be affirmed. The employer elected to receive electronic correspondence, but failed to open the chargeback determination until well after the appeal deadline. Therefore, the employer's appeal should be deemed as late. Affirm the AT, late employer appeal, chargeback.
Concur with Commissioner Dimerson.
Thank you. We will remand the case. And Commissioner Alvarez, this will result in a decision. Did you want to dissent?
Short form dissent?
Yes, sir.
Case number 2693252, Commissioner Alvarez.
The decision is not supportable. This is a one-party hearing. The claimant's rights will not be violated by acknowledging that commission records reflect that the claimant filed a timely appeal, and timeliness of the appeal should have never been an issue in this case. The case does not need to be remanded to admit the timely appeal and evidence. With regard to the underlying issue, the claimant has consistently stated that she tried to report but was unable to get through the commission on overwhelmed phone call lines. The reporting ineligibility should be reversed. Reverse the AT deemed timely, reporting eligible.
There is insufficient evidence in the record to support the AT's decision that the claimant filed a late appeal. The file contains what may have been a timely appeal filed via email, which would be relevant for the outcome. But that evidence is not in the official record of the case. Accordingly, we remand this case to the appeal tribunal to allow the evidence of a timely appeal to be admitted into the record.
Reverse the AT, timely claimant appeal, reporting eligible, memo to UIO and CS to contact the claimant for necessary information.
And I'll short form.
Yes, sir, Commissioner Dimerson.
Thank you.
And we will send that memo, Mr. Chairman.
Thank you.
Case number 2698258, Commissioner Dimerson.
The AT decision should be modified. The claimant was discharged for excessive absenteeism. Since the majority of the claimant's absences were due to personal illness, I agreed that the claimant should continue to be qualified for benefits. In addition, the employer's account should be protected from charge under a medical separation analysis. Accordingly, we should modify the AT decision, no misconduct, no chargeback, MVI.
Ms. Miller, I would agree with Commissioner Demerson.
Agreed.
Thank you. We have a unanimous decision.
Case number 2709655, Commissioner Dimerson.
The appeal tribunal decision should be reversed on timeliness. The entirety of the employer's appeal window took place during the time that TWC was experiencing technical difficulty receiving claims. As such, the employer's appeal should be deemed timely and the case resubmitted for merits testimony. In the alternative, I would also support a vote to hold a rehearing in this case. The employer stated in its appeal to the commission that its witness was not available to participate due to attending another hearing. As such, I would agree to rehear the case in order to gather witness testimony regarding timeliness.
Ms. Miller, I would agree to rehear.
Rehear.
We will rehear the case.
Case number 2714677, Commissioner Dimerson.
The AT decision should be modified to add an adequate response ruling. As to the job separation, the home health care precedent applies to this case, since the employer operates in the home health care referral industry as a staffing agency. Therefore, the employment relationship continued until one party clearly notified the other that it is ended. In this case, the employer's policy alerted the claimant that she had 72 hours to request a new assignment after her last assignment ended, or she would be deemed to have voluntarily quit. Here, the claimant's assignment ended when her client was hospitalized. The claimant was offered a new client that same day, but she declined. After that, the claimant, by her own admission, did not attempt to request a new client for 5 days until 5 days later. Thus, per policy, the employment relationship ended when the claimant quit after waiting more than 72 hours to request further work. In addition, the evidence shows that the claimant did not properly convey her availability to the personnel department as required by policy. Under these facts, the claimant should be deemed to have quit without work-connected good cause, and we should modify the AT decision. Voluntary leaving, no chargeback, add adequate employer response ruling.
The decision should be reversed. The claimant contacted the employer by reporting in person and requesting a new assignment. Contrary to the testimony of the employer's witness, the employer's policy does not state that the claimant needed to call any particular department. It merely states that the claimant needed to contact the employer and request an assignment. When the employer failed to offer the claimant a new client after her assignment ended, the claimant was laid off due to the lack of work. Reverse the AT, no misconduct, chargeback.
Reverse the AT, no misconduct, chargeback.
Short form?
Yes, sir, Commissioner Demerson.
All right, thank you.
Case number 2717078, Commissioner Alvarez.
The AT decision should be reversed. The claimant quit the job with the employer after 4 days because he considered the wage rate unsuitable. She had been filing for benefits when she took the job, and her maximum wage demand was greater than the wage rate paid by the employer. In her prior employment, the claimant made almost $60,000 a year. The position was clearly unsuitable, and the claimant met the requirements under Section 207.045G1 of the Act to be qualified for benefits. Reverse the AT, no voluntary leaving, no overpayment.
The appeal tribunal decision should be affirmed. The claimant gave inconsistent information between her testimony and her fact-finding statement as it related to the rate of pay she was to earn. In addition, the claimant's resignation letter focuses primarily on her feelings that she could not perform the job satisfactorily. In sum, the claimant quit due to personal reasons and without work-connected good cause. We should affirm the AT decision, voluntary leaving, overpayment $3,014.
Reverse the AT, no voluntary leaving under section 207.045G1, no overpayment.
Short form.
Yes, sir, Commissioner Demerson. I have your short form.
Thank you.
And that is the last pulled UI case on docket 8. I did send you the UI short form dissent list for docket 8 earlier in the meeting.
Mr. Chairman, if I can, A question, real quick before we vote on docket 8. It's appeal 2636092, case number 10. 2636092. Again, case number 10.
Certainly, sir.
Okay, just trying to clear up that vote to make sure that we're all on the same page.
Okay. This is a unanimous vote, disaster impacted.
Okay, all right, that's good. We have it. Thank you.
Thank you, sir.
Ms. Miller, I'd like to also go back if it's okay.
Absolutely.
On case 2687902, 2687902, I just wanted to confirm the decision after all.
Yes, sir. One moment, please.
I may need to clarify something.
2687902.
Yes, ma'am.
It's like this case number 18.
All right, one moment. I'm almost there. 2687902. Yes, sir.
So in this particular case, I short formed it, but I also would agree to a remand as well. I failed to reference that.
Okay, then we have a unanimous vote to remand the case.
Yes, ma'am.
All right, thank you very much. Then I believe it's time to move to the short form dissent motion, which I did send the UI short form dissent list for docket 8 earlier in the meeting.
I'll move we accept staff recommendations on the remaining UI cases on docket 8.
I second the motion except for those cases on which I'm dissenting as reflected on the UI short form dissent list for docket 8.
I concur with the chairman's motion, except for the cases on which I am dissenting, that's reflected in the UI short form consent list for docket 8.
Motion passes with the exceptions noted.
Thank you very much.
Thank you. This brings us to the end of agenda items 3 through 7. Let's pause for a few moments to reset for the rest of the meeting.
Thank you, Sherry and team.
Thank you, Commissioner.
Chairman, we should probably go ahead and assign everything to Commissioner Alvarez right now. I think I don't see him on the screen. So
Been moved and seconded, unanimous, so ruled.
we almost got there.
Mhm.
Missed
That
it.
vote took place before he got back on, so
Okay, I did too. So
it was a majority vote. All the work has now been assigned to Commissioner Alvarez.
all right.
Come on. No money.
All right, we'll take it piece by piece then. You guys ready?
Yes, sir.
The staff doesn't have anything to report under agenda item 8. Agenda item 9 is discussion, consideration, and possible action regarding vocational rehabilitation, substance use disorders services.
Good morning, Commissioners. For the record, Jason Baden, Vocational Rehabilitation Division. Currently, vocational rehabilitation substance use disorder services are provided for individuals who are eligible for VR services and who have been clinically diagnosed with a substance use disorder and meet the requisite criteria to receive such services. In addition, customers must maintain and document a minimum of 30 days of sobriety before eligibility determination and be actively participating in treatment or receiving other supports to maintain sobriety. Customers must also continue to meet the required eligibility criteria to continue receiving these services funded by VR. While the 30-day sobriety provision and the continuance of sobriety have been longstanding policies, it's prevented VR from taking advantage of opportunities to fully engage with and assist both potential and existing customers. In accordance with the flexibility provided in federal regulations, and after a scan of other state policies and in review of evidence-based approaches, staff seeks direction on removing the policy requirement for a customer to maintain and document 30 days of sobriety before eligibility determination, and to remove the requirement that services be placed on hold in the event of a relapse. Instead, customers will be expected to recognize their disability and understand the need for services, to participate in treatment in the VR program, and make progress in completing their treatment and achieving goals as established in their employment plan as set forth in your materials. This approach will align with our partner agencies that serve individuals with substance use disorders, often co-occurring with mental illness, and will help us better coordinate services to joint customers. Commissioners, this concludes my remarks, and I'm happy to answer questions if you have any.
Any questions or comments?
None here, Chairman.
None here.
Do we have a motion?
Chairman, I move that we remove the policy requirements for a vocational rehabilitation customer to document 30 days of sobriety to receive VR services and remove the requirement that services be placed on hold in the event of a relapse. Instead, customers will be expected to recognize their disability and understand the need for services, participate in treatment and the VR program, and make progress in completing their treatment and achieving goals established in their employment plan as presented by staff.
Okay. Second that motion.
Been moved and seconded. I think the vote's unanimous. This brings us to agenda item 10, discussion, consideration, and possible action regarding new certification and recertification of community rehabilitation programs to participate in the purchasing from people with disabilities state use program.
Good morning, Commissioners, Mr. Serna. Juan Garcia with the VOC Rehab Program. Texas Human Resources Code, Section 122.013, requires the Texas Workforce Commission to establish rules for the certification of community rehab programs to participate in the Purchasing from People with Disabilities Program. Concurrently, Chapter 806.41 of the Texas Administrative Code sets requirements for participation in the program and subsequent adherence to those requirements when a CRP has been certified. CRPs must reapply every 3 years prior to the expiration on the certificate. PPD staff reviews each completed application and required documentation, and if acceptable, makes recommendations to the Commission for approval. The PPD program has reviewed applications for the following 2 CRPs wishing to receive initial certification and 8 CRPs wishing to continue participation in the PPD program through recertification. With respect to the new certifications, we have 2 CRPs, Training Rehab and Development Institute from San Antonio and L&V Enterprise Resources from Houston. With respect to the recertifications, we have 8 CRPs. Spindletop from Beaumont, Goodwill Industries of Houston, Redirection Opportunities from Fort Worth, RG&G Construction Services from Weslaco, Rukon Inc. from Huntsville, San Antonio State Supported Living Center from San Antonio, Second Chances from Humble, and Texana Center from Rosenberg. Staff seeks direction regarding approval for the 2 new CRP certifications and 8 recertifications for community rehab programs to participate in the Purchases from People with Disabilities program. With that, I'll answer any questions you might have.
Answer questions?
None here, Chairman.
None here. Did you mention one from Huntsville?
Yes, sir. That was the Rukon Inc.
Okay. Okay. Got it. Thank
Do we have
you.
a motion? Do we have a
Chairman, I
motion?
move that we approve the certification and the recertification of the community rehabilitation programs as discussed by staff.
Second.
Been moved and seconded, vote unanimous. This is agenda item 11, discussion, consideration, and possible action regarding temporary suspension. 40 TAC Chapter 807, Career Schools and Colleges, Rule 807.387A, hearing procedures due to the COVID-19 pandemic.
Good morning, Chairman Daniel. How's my audio? Perfect. Thank you. Good morning, Commissioner Alvarez, Commissioner Demerson, and Mr. Sarno. For the record, Carrie Ballas, Workforce Development Division. Texas Education Code 132.152 establishes the right of a career school or college to have a hearing to contest administrative penalties assessed by TWC. TAC Chapter 807, Career Schools and Colleges rules, specifically Rule 807.387A, states that all hearings shall be conducted in person in Austin, Texas, unless the parties agree to a telephonic hearing or request a different location. As a result of the measures put in place to ensure public safety during the COVID-19 pandemic, TWC's Commission Appeals Hearings Unit has been unable to accommodate in-person hearings, and this is leaving administrative actions unresolved and in some cases preventing or delaying students from receiving refunds of tuition and fees. 40 TAC 800.8 authorizes the Commission to suspend the operation of an agency rule if the Commission finds a public emergency or imperative public necessity exists, and that the suspension will best serve the public health, safety, or welfare. So with all of that in mind, staff seeks direction on the temporary suspension of 40 TAC 807.387A, thereby allowing the suspending the requirement of in-person hearings in Austin. The suspension will allow the Commission Appeals Hearing Unit to schedule telephonic hearings and adjudicate appeals in a timely manner. I am available for any questions that you may have, and thank you.
Comments or questions?
None here, Chairman.
No questions here. Carrie, just one statement in regards to this action that we're taking right now. Is this something that we need to make permanent, or at least look at, so that if we're ever in a position like this, kind of look at this so that we don't find ourselves in this position again? So.
Good question, sir. Following later in this year, our Career Schools and Colleges rules will be open for their 4-year yearly review. This is a rule now in light of what we've learned about a pandemic and other kinds of unforeseen occurrences like this. We will definitely revisit this rule and go ahead and build in some other ways for us to accommodate hearings.
Sounds good. Thank you.
Thank you.
Any other questions or comments?
None here, Chairman.
Do we have a motion?
I move that we suspend 40 TAC Section 807.387A until the public emergency has passed and Commission Appeals Hearing Unit resumes in-person hearings as recommended by staff.
Second.
Been moved and seconded, vote unanimous.
Thank you.
Go to agenda item 12, discussion consideration of possible action regarding the statewide initiatives funded with Workforce Innovation Opportunity Act, temporary assistance for needy families, adult educational literacy, child care, and other state level funds.
Good morning, Chair, Commissioners, Mr. Cerna, Angie Nelson-Wernley for the record. Today, we are requesting additional funding for the Veterans Workforce Outreach Initiative. TWC most recently procured this initiative in 2018 for $425,000 to enroll hard-to-serve veterans in finding and retaining employment. The intensive case management services address major barriers such as homelessness, substance abuse, physical, mental, or learning disabilities, post-traumatic stress disorder, ex-offender status, recent discharge from military services. This initiative is currently operating in San Antonio, Houston, Dallas, Fort Worth, and El Paso. We are entering into our third year of renewal periods, and there's been an increase in the cost per participant and support services. In 2018, the grantee implemented the program with 7 case managers and planned to serve and enroll 426 participants. Due to turnover and cost increases to hire and retain qualified staff, increased costs for services, including support services such as commercial driver's license, work equipment, certifications, etc., we are requesting additional funding to cover the increases in the cost per. Requesting an additional slight increase in funding and a slight decrease in the original target. We are going to reprocure this initiative in 2022 to address this issue longer term. We are requesting today to increase the WIOA funding by $60,000 for a total of $485,000 and slightly reduce the target from the original 426 to 386 to meet the current cost purse. I can answer any questions you have.
Any comments or questions?
I do have a comment, Chairman. Commissioners, at this time, we are more than halfway through the fiscal year. This program still has about $100,000 left in its budget this year and has only enrolled 259 participants to date. I would like for this initiative to play out for the remainder of the year and reconsider increasing the funding for next fiscal year's budget.
Sir, this initiative, just want to note that this initiative is not actually on a fiscal year. The actual grant period, because it's a competitive process, the new grant year is actually supposed to start March 1st.
Okay. Can we still wait?
We could enter into the exact same amount. The grant actually ends this Friday. So we were looking to increase by the 60,000, kind of meeting, halfway there. And like I said, wanting them to serve, they served 335 last year, and they are on target for about that amount. So this would increase the enrollment by 51 if we would increase the 60,000 for this coming year. Or the other option, we could amend the cost per and allow them to fully expend the 425,000, but they would only serve 335 participants.
They served, Commissioner Demerson, I'm sorry, I'm cutting in front of you, I believe.
And mine will be real quick. So Angie, the existing contract that they have, this ends in March?
It ends actually Friday. So we're entering in the current renewal. It's a competitive procurement. So we've got 5 years that we can actually renew. And we've got it on the procurement schedule to re-procure next year so that we can address and see what types of applications and cost per and services we can get competitively out in the market.
So we would be increasing 60,000 right now?
It would just be for this year. And then we could go back to and procure the 425 next year.
Yeah, so I'm trying to wrap my head around 60,000 right now, and it ends Friday. I'm not sure.
The 60,000 is for the period beginning March 1st.
Okay.
Yes, sir.
I mean, what we have here is a very incomplete proposal by staff. I've probably got 15 or 16 questions about it. To make a decision on something that happens in 6 days. And that's just that you can't make a decision from an incomplete sort of proposal here 6 days before a decision has to be made. I think it's a good program. I think that we do no one justice by making a rash decision on incomplete information 6 days before the decision needs to be made. We'll vote on it. I'm in agreement with Commissioner Alvarez. We do not need to take action today. We need to do a better job of outlining this proposal, understanding what this means for this. How does this fit into our other veterans proposals? How does it fit in with the Veterans Network? There are so many unanswered questions here that I'm not even sure we can all get. I'm gonna ask the questions, but I'm not sure we can get them all answered today. You put us as commissioners in a very precarious position in making too quick decisions on incomplete information. When we talked about all of these programs in July when we were making budget decisions for the agency, and none of this came up then. So I think we need to have a more in-depth conversation. I think we need more information, lots more information. And I'm not comfortable moving forward today either.
Chairman,
Angie,
I totally agree with you.
Angie, yes, sir. Mr. Chairman, we will bring this item back to the commission with a more thorough analysis. Angie, were the offices briefed prior to today?
Yes, they were. They were briefed. Trying to get all my days straight. It was actually supposed to be on the last commission meeting because of the ice storms and everything that was going on. So we postponed it, but it was briefed 2 weeks prior.
Okay, we'll do a better job, Mr. Chairman, at briefing the offices as well as formulating the rationale for the proposal. It's my understanding, however, that the grantee has indicated because of the increase in cost, they were looking for much more of an increase. We don't believe that an increase in just money would suffice, but we'll flesh that out more and come back to the commission with a more detailed proposal.
So here's my 2 cents. Thank you for that. Here's my 2 cents worth. And I don't necessarily believe that this needs to happen. I wasn't here when this was originally laid out, so I don't know how it was laid out. But here's what I'm gonna say, nonetheless. If we need to somehow adjust some commission action on the number of target enrolled participants or the amount of money, those seem like contractual things to me, which makes them operational, which puts them in your purview, Mr. Cerna. But if we need to take some action to allow us to modify this contract to perhaps be able to expend more money per veteran that we're assisting, I would likely be happy to do that today. I personally don't think we need to do that. I think that's a decision that we can make on the contracting basis, but I am looking for a little advice here. If that needs to happen so that we can do something for this contract that takes effect March 1st or whenever it is, let's do it. Otherwise, let's bring this back when we can do a much better job of considering it.
The grant is currently funded at the agreed to levels with the agreed to targets. So we have time to make any kind of adjustment since the year that we're talking about. The grant year is just beginning on Monday. So we have time. We have plenty of time, as Commissioner Alvarez pointed out, for us to be able to come back and discuss any changes to either the targets or the additional funding to the grant.
Okay.
Ms. Nelson, I want to thank you for the presentation. As you know, all offices are in support of our veterans. We just want to make sure that we utilize the funding to its fullest potential. I will tell you that I appreciate the fact that you did meet with the offices regarding this particular agenda item. But I do think that I know that staff here had specifically asked about the need to increase funds and if we were going to meet those targets. And so I think that's what brought this agenda item to my attention. We've been doing it for a couple of years now, and I just want to make sure that all the money that we do allocate is fully used and before we increase it, and especially if we're asking boards to reevaluate where their money is being used and best suited. So I appreciate your presentation and your meeting with staff, but yeah, at this time I just can't take any action. If you're ready for a motion, Chairman, I agree with you totally on this particular agenda item. I would move that we table this item for a later date.
Second that motion.
Right. But it's been moved and seconded to table the item. I guess technically we don't have to do that if staff pulls it off. I'm not opposed to the motion. The only thing I would add, if it's acceptable to you, the author, is that we table it pending staff bringing this back to us for further consideration. That being the case, vote unanimous.
I would agree with that, Chairman.
Okay, thank you.
Thank you.
Thank you, Angie.
Addendum item 13 has been postponed to a future meeting.
Yes, sir.
Agenda item 14 is discussing serious possible, this is on child care funds.
Yes, sir. We only have one item, and that's
I
childcare.
mean, I can read this whole thing, but I've been reading all of them and about child care. So, and I see Reagan on the screen. So.
All right. Good morning, Chairman, Commissioners. For the record, Reagan Miller with the Child Care and Early Learning Division. This morning for your consideration is a report to the Administration for Children and Families on Texas's planned use of the Coronavirus Response and Relief Supplemental Appropriations Act funds, or CRSA for short. Texas will receive over $1.1 billion through these one-time CRSA funds. ACF issued reporting instructions to states on February 11th on the required plan content, which by statute is due no later than February 25th. ACF notes that states may not have yet determined and finalized how they plan to spend the CRSA funds, and states can make changes to this initial plan. The planned use of funds report is structured based upon the categories that ACF requested states use and includes information on how TWC may invest these funds to support direct child care subsidies, grants other than subsidies to stabilize child care providers, assistance to providers not participating in the subsidy system prior to the pandemic, and other strategies the state is considering. We will continue working with your office on specific implementation details over the coming months as we refine our planned use of these CRSA funds, and I'm happy to answer any questions that you have.
Questions or comments?
Chairman, I just want to inform Reagan that when I read this discussion paper, it's an excellent discussion paper, Reagan. I love what the funds are going to be used for. I think our providers are going to be excited about that and what we're going to be able to do, things that we've never been able to do in the past. So thank you for that. And thank you for being creative on this.
Yes, sir.
Along those lines, Chairman Reagan, thanks for the briefing you and Allison, briefing our team last week with these. We appreciate that, even during the snowstorm. So.
Yes, sir.
You know, we've been challenged with a lot, and I would be remiss if I did not take this opportunity to thoroughly embarrass Reagan and point out how thankful I am for their ability to pivot quickly. Washington passed this, Department of Labor and others involved, got this to us 14 days before the statutory due date. And so a lot of the work that's been done here has been very quick, it's very thorough. You know, we're blessed here at TWC with a number of great directors in all of our divisions, frankly. I appreciate everybody's flexibility, but Reagan's on the hot seat right now, so we'll just deal with this one. Great work for something that had a 14-day turnaround. We briefed a number of legislative offices about this who've had an interest in it, and so this didn't happen in a vacuum. There's been a lot of work going back and forth on this, and I sincerely appreciate our ability to meet those statutory deadlines and have a work product here that Commissioner Alvarez pointed out as being very solid, very thoughtful, very well thought out, and we're very much going to be able to execute this as we develop that.
Thank you, Chairman.
Is there a motion on this? Do we need a motion on this?
Chairman, I move that we approve the CRRSA plan as presented by staff.
Second that motion.
All right, it's been moved second, vote unanimous.
Thank you, Reagan.
Agenda item 14 is more than just childcare. It's almost everything dealing with the pandemic. We do have one more item on agenda item 14. Yesterday, which was February 22nd, the governor sent me a letter indicating that he had suspended Texas Labor Code section 204.048 to the extent necessary to delay the commission's computation of the 2021 unemployment insurance tax rate. The suspension will remain in effect until June 20th, 2021. Effectively, what this does is it gives us time to delay setting the annual employer tax rate. which was being driven by 204048, which is the voluntary contribution provisions that are both in statute and our rule. With the suspension of that requirement, it allows us to spend some more time working on a couple things. These should be of note to both employers and employees. But the setting of the tax rate, there are some statutory changes that are being considered to the general tax rate. This gives the legislature ample time to consider those statutory changes and how those might apply to the COVID-19 disaster. It also gives us time as an agency to really consider all the ramifications of the tax rate, both the statutory self-implementing parts of the tax rate and the ones on which we have quite a bit of latitude as a commission. The governor took this action, and I think wisely so. It gives us the added time and the ability to very thoughtfully consider all of the impacts that the tax rate will have, and it keeps us from having to set the tax rate imminently, which would have been in the next couple of days, because of one provision that the small percentage of employers actually avail themselves of. And so I think it gives us a better opportunity to make a more fair and a more forward-looking tax rate for all employers. In order to fully implement this action and address this, what I believe is a public necessity, we do need to, as a commission, suspend a rule that accompanies that particular section of the labor code. Then we would be able to align our rules with what the governor's done here on the statutory suspension. Let me present a motion, and then we can have as much discussion as we need, because it would all be in order. Based on what I just said, I move we suspend 40 TAC section 815.119 until June 20th, 2021, pursuant to section 418.016A of the Texas Government Code and 40 Texas Administrative Code section 800.8 to temporarily suspend the voluntary tax contribution program and enable the agency to delay the tax rate calculation so that Texas employers and the state's economy will be better positioned to recover from the ongoing pandemic. Further, the commission directs the Office of General Counsel under this motion to draft an order memorializing the action taken today. That's my motion.
And I'm going to second that motion.
Chairman and Commissioner, I would agree to that as well.
If I'm hearing correctly, I believe the vote's unanimous.
Yes, sir.
Gentlemen, I don't want to cut off any discussion or comments or questions you may have. I'm certainly happy to answer those that I can. If the vote's unanimous, then we'll say that the vote's unanimous and ask the General Counsel to conform this to how it needs to be conformed.
I appreciate your work on this, Chairman, and also Commissioner Demerson on this as well.
Hey, I really appreciate you guys staying up to date on a lot of moving parts. I'm doing the same. You know, we only meet once a week in open meeting. We don't really get a chance to discuss these things, and rightly so, because that's the way it's set up. But I appreciate the fact that everybody does their homework and we stay up on these issues. And it seems like we're all having the conversations that we need to be having to solve a lot of problems simultaneously. There are more problems to be solved. I don't pretend that isn't so, and we'll keep working on it. And you know, it's things are coming. They come fast and they change often. And I just appreciate everybody's willingness to continue to tackle these in the spirit that we've been tackling them.
Chairman,
it's the tie, Chairman.
I like
the tie.
Commissioner Alvarez keeps talking about the time, but I'd like to thank you for your work in this effort. Early on, Texas employers were calling with a lot of questions and the like, and I know there was a lot of background work taking place, and this is a good outcome. And so I continue to appreciate the leadership of the governor, concern and his interest in our Texas employers as we proceed forward. So good work. We'll get to where we need to go.
Thank you very much. Right. If there's nothing else, let's move on to agenda item 15. This is discussion, consideration, and possible action regarding approval of local workforce development board nominees.
Hi, good morning, Chairman, Commissioners, and Mr. Cerna. For the record, Shanta Williams with the Workforce Development Division. And before you for consideration, our workforce board nominations for Alamo, Cameron County, Deep East Texas, Heart of Texas, and Lower Rio Grande. Staff recommends that all nominees be approved, and I'm here to answer any questions you may have.
Any questions or comments?
Chairman, the only thing I want to say is I really appreciate the hard work that Ms. Williams puts in screening these board members. So I appreciate that, Ms. Williams. Thank you, and for the detailed information that you provide to the office. So I just want to say that.
Chairman, I may have a question about Workforce Solutions Deep East Texas. I noticed Mr. Eddie Hopkins is on there, and no, I'm teasing with Eddie in that just the work that all of them are doing. But I agree with Commissioner Alvarez's words, and we're bringing good members to our Workforce Solution boards.
It's rare that Commissioner Demerson would call out someone by name. That felt like to me of some sort. So.
He knows them. He knows. He probably owes them or something. But I will tell you that, as you know, Chairman, and I think we've all had this discussion during the state conference when we met with our board chairs and our executive directors. I think we all stress the importance of having the best of the best serve on our board. And so that's why I think about every time this agenda item comes up, it's something that we certainly, put a lot of value on, because we do want the best of the best to represent us around the state. So Ms. Williams, thank you for the hard work that you put into the recommendations. And I know that sometimes we do have questions regarding some of the board members, but generally, I appreciate the screening that you do and the briefings that you give to the offices.
Any additional questions or comments? Is there a motion on this item?
Chairman, I move that we approve the board nominees for Alamo, Cameron County, Deep East Texas, the Heart of Texas, and Lower Rio Grande Valley.
Second that motion.
Then move second, vote unanimous. Thank you.
Thank you.
Nothing on agenda item 16. Gentlemen, we have a real treat today. Michael Britt has made himself available to us to give us a legislative briefing. So all those questions that I know you've been wanting to ask, this would be our opportunity to ask these of Michael. Michael, the floor is yours.
Thank you, Mr. Chairman.
Don't say thank you so tentatively. Don't say thank you so tentatively. Just charge right in.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, Michael Britt, Governmental Relations. Yesterday, the U.S. House Budget Committee approved Senate Concurrent Resolution 5, which is the American Rescue Plan. This measure includes the appropriation titles that will make up the next round of COVID-19 relief. The bill is expected to be considered by the full U.S. House this coming Friday. Last week, Texas House Appropriations Chairman Representative Greg Bonin announced HAC subcommittees for the 87th Texas Legislature. The House Appropriations Subcommittee on Articles 6, 7, and 8, which has oversight over the Texas Workforce Commission, consists of the following members: Representative Armando Wally as the chair, Representative Cecil Bell Jr. as the vice chair, and Representatives Ed Thompson, Representative Steve Toth, and Representative Alex Dominguez. Finally, yesterday, Senator Zaffarini filed two bills that are TWC legislative proposals. The senator filed Senate Bill 694, which is TWC's legislative proposal related to the consolidation of the TRS assessor evaluator functions, and Senate Bill 695, which is TWC's legislative proposal related to notice of assessments and methods of service. And that concludes my remarks, and I am now happy to answer all the questions that you gentlemen have.
All right. All the questions and comments?
None here, Chairman.
I guess I don't have any for Michael right now. We're good to go.
I feel like I might have oversold it then if we don't have any comments. Michael, thank you so much.
Thank you, gentlemen.
All right, Mr. Cerna, do we have an executive director's report today?
Just one unfortunate bad piece of news. We've lost an employee, one of our customer service representatives in a call center to COVID-19. And we have another employee who is not doing very well right now. So we will keep that family in our thoughts and prayers. But I thought you all would want to know that is now 4 employees that we've lost to this virus. So.
Unpleasant news. Thank you for letting us know. I do want to know, and we do want to hold up their family.
Yes, sir. That's all I have, sir, unfortunately.
All right.
Chairman, under this agenda item, I do have something that I'd like to state, if that's okay.
Yes, sir.
Yes, sir.
Back in March, we the waiting week was waived for the pandemic claims. As we all know, statutorily, we know that the governor has the ability to do this. I just wanted to make sure that we were aware that back on February 20th, 2021, 77 Texas counties were declared major disaster areas, making federal funding available those affected individuals, including disaster unemployment benefits. Shouldn't we waive the waiting week for the new disaster, which is what we just experienced last week, unemployment insurance claims? Should we consider waiving the work searches for those individuals affected by the 77 counties, and I'm understanding that we may even increase the 77 to a few more? So really just wanted to make a distinction, what was laid out back in March of 2020 with the pandemic and the waiting week for those individuals that were affected by the storms that we experienced last week. Just wanted some distinction between the two.
Work search has been waived and is under consideration for how long that period would be.
Work search is waived for last week and this week.
And
That's
I
correct.
assume we'll continue to look at that to
Yes,
determine what's the right amount of time for that.
Yes, sir, we will. We will for those 77 counties that were in the president's disaster declaration. And we will also
on waiting week.
We'll look at waiting week as well and see what authority we have. I believe that the governor's order is still in place.
So is the governor's orders in place for the pandemic, Ed, or does it have to be a different one for the disaster?
And that's what I'll find out, sir, for you.
Because I was looking at it.
It's for the pandemic. His original one was for the pandemic.
That's correct. In section 207.021, we know the executive order allows them, but again, that was the only reason I brought this up at this time, was just to make sure that there was a distinction between the two.
Yes, sir.
All right, anything additional?
No,
Not
at this time.
The time is 10:55. Texas Workforce Commission is now going into executive session in room 644 to discuss the appointment, employment, evaluation, reassignment duties, discipline, or dismissal of the executive director, internal auditor, executive staff, or other personnel pursuant to Texas Government Code, section 551.074A1.
Yeah, he's going to come back in.
Oh, okay.
Yeah.
I need to see if I can make Mr. Simon that guy. Bye-bye.
Okay, I'm back on.
All right, perfect. The executive session is now concluded. The time is 11:28 a.m. Is there any other order of business to come before the commission?
None here, Chairman.
Mr. Chairman, I had one order of business in here. I'm going to show you guys something here. This is an award that comes from the Texas Restaurant Association, and it's a partner award that they gave to the agency and all the work that they're doing. And our board commissioners have been in virtual town hall meetings with them a number of times. And so there's a staff member that actually made this, and that's COVID. This is the fork, and so they're putting a fork in it from that standpoint. And so, but they really appreciate the partnership of the agency. They mentioned the work that Courtney, Jen Trogue, Mary York are doing with them, and they really appreciate all of those efforts. And then the staff behind the scenes that are working. Governor Abbott, I think, was addressing them on yesterday or today as well. And so they're open for business and ready to do a lot of things, but they appreciate the work that's been done by the agency in that regard, and wanted to give us the Resilience Award as well. So it's a guy on the team made it, and so he spray painted the balls, but they're putting a fork in it from that standpoint. So thank you guys, and thank the Restaurant Association for their support.
Thank you.
Yeah.
Any other business? Is there a motion to adjourn? A motion to adjourn?
Chairman, I move that we adjourn.
My second motion.
Been moved and seconded to adjourn. This commission meeting is adjourned.